We'll be starting slowly the session. I still see some people coming in, but I think we're probably good for now. I'll show you some slides, if I can. That's a fantastic panel for this morning, for the legal landscaping session. My name is Malte BeyerKatzenberger. I'm the host of this session. I'm a lawyer by training, but try to develop myself into more of a policy developer. We had some remarks on, well, the proportion of lawyers in the audience in total. Maybe I can see a show of hands how many lawyers we have now here in this session. There were roughly 10% of the audience in the morning. It's not an awful lot, that's very good, because the session is designed to educate you or to show you the potential of GDPR and other tools for making MyData happen. There was a comment on the function of law. My own perspective on this, and that's why I work for the European Commission, where we make laws at some point. But for me, laws are the means to consolidate a political consensus into an agreed text that is binding on people. So I have a functional approach to law, and that's why I chose also to become a member of a lawmaking body. I'm not responsible for GDPR. I'm working in a team on data policy and innovation, which was good a few years ago, but it's a bit challenging these days. Before we go to the fantastic speakers who tell you the legal landscaping, I abuse my time as a moderator for just attracting your attention to a few funding opportunities that we have open that could be interesting for you guys in the room. So but before doing so, I want to pay tribute to Drummond Reed, who's in the audience, because he inspired me in 2013 to first get into the MyData subject. And at the same time, we had a couple of initiatives like the Key Foundation. Martin Luhmann is in the audience, maybe here or at least at the conference, who were approaching the Commission to say, can we do the internet differently, and can we do personal data handling differently? And I took upon the challenge to say, does that make sense, what you guys propose? So I've been trying to observe the MyData evolution over time, connecting some dots a few years ago to make this audience really truly European and eventually global. At the moment, we're focusing in the team more on non-personal data rights and questions around that. That's my main point of expertise. But we have two interesting programs that try to support what we still call personal data spaces. Don't get stuck at the semantics, because it doesn't matter. What we mean by personal data spaces is essentially a MyData approach, and I'm the MyData ambassador, if you want, inside the European Commission and trying to spread the gospel in the different teams, in the different services. But we have two interesting programs at the moment. One is called, very modestly, the Next Generation Internet Initiative. And the second, where I work, is the Data Economy Initiatives. And it is interesting because you will recognize a lot of the things, the aims of the Next Generation Initiative, as also the aims of the MyData movement. And this is not only interesting for that point, but also because there's a lot of funding opportunities there. So for those familiar with the Horizon 2020 funding program, that's our large European Commission funding program, there's typically large projects been called for in the order of 1, 2, 3, 5 million. And we have, for example, a very good project which was present here last year, which is My Health, My Data. That's our flagship that we personally fund. And these are the two funding calls that, under this initiative, Next Generation Initiative, may be of relevance. The slides will be shared. There is a clickable link behind the two acronyms, but if you put them on Google or a search engine of your preference, you'll quickly get to the description of the calls. I'll use the time still to say how they work, because they are a bit different from what we traditionally do. Traditionally, we try to have large consortia from a lot of countries, and this time we try to do a thing that we call cascading grants. So there are two types of funding opportunities. The first is basically you are an intermediary that receives the money from the Commission of a large magnitude, but your main task is then to identify the eventual recipients of that money that do the actual research and innovation challenges. So you have to build a coherent vision around that process and structure it around a number of funding themes, which I'll be showing in a second. Or you could wait for these intermediaries to be put in place and then go to these intermediaries that take the commission money and dispense this in a number of small grants in the order of 50,000 to 200,000 euros, which for us is small money because the administration of public money is always a bit of a headache. So we try to do it in large portions, which means less overhead on our side. So these two roles exist as funding recipients, and the themes that we want to fund under the Next Generation Internet have been defined. They are more explicitly explained in the ICT13 call descriptions, what we mean by all those words that are put on the slides here. Just to say that we have two sets, because it's not always very easy to understand from the description of the call. We have two sets, and they come in two stages. And the first set of funding objectives, for this set we have already selected the intermediaries. I think we will publish the results shortly. And these intermediaries will start to actually, out of their own initiative, set up the process, which is open as of 2019, early 2019, to actually then do the micro grants that I just described. And then there's a second set of funding objectives under the second list of bullets, where we will call for these intermediaries as of October this year, with a funding call that closes on the 28th of March 2019. So if you are more in the business of grant management and want to get involved there and design basically this grants program along these objectives, watch out for that call, which opens very soon from the Commission's websites. Final slide for the introduction. We also, in parallel, that's a bit the problem working in large organizations, that different teams work a bit in parallel. And this is my own contribution, that we have also identified MyData and personal data walls, spaces, trust frameworks as a challenge for the data economy. So under the umbrella of the design of an economy in which data can travel as much as they should, personal but also non-personal data, we have designed a lot of some policy which accompanies GDPR and which focuses at the moment mostly on non-personal data. But our funding program, which is the ICT13 Call, which is here displayed at the bottom, addresses both personal data platforms and industrial data platforms, which may contain personal or non-personal data. So both types of platforms, industrial data spaces and personal data spaces, are being called for, with the idea that we should now make it happen. That was the slogan of the first session, that we should now get to real-life examples where the approach of MyData works, and we use personal data platforms as a vehicle for that. Don't get stuck at the semantics, at the technicalities. We're pretty much open to proposals. This call also opens in October, but you can also start preparing for it by finding partners across the continent. And then it closes on the 28th of March as well. Again, I should say our funding program is financed by European taxpayers. That's why the recipients can only be European established companies. If they want to receive money, I think we can have non-European established players that do not claim money as consortium partners, so they can bring in stuff, bring in even own resources, but they cannot be funding recipients under our funding programs. And that's pretty much the same, I think, in all countries, the US, elsewhere, that nationals can apply for national funding. And this is the case also here. But with this, I close my little advertisement for EU funding opportunities, which is what you may be interested in. And we now move into the legal session. I have a very, very good panel here on the couch. And I'm happy to be on this stage together with Elizabeth Renieris from Evernim. She's the Global Policy Counsel and a polyglot lawyer. As you could see on the description on the website, she has worked in a lot of countries and is now working for Evernim, an organization I don't think I have to introduce specifically here, and she'll probably explain a bit about that organization. She'll open us, again, the legal framework that we have in Europe, but also globally for personal data management, with especially GDPR, but also other relevant legislation, such as the e-privacy directive, which may turn into a regulation quite soon. And I'm very happy that she's here. She's joining us from the US. And the same for Willem Debeuckelaere, who is head of the Belgian Data Protection Authority, called Privacy Commission, and has been so for many, many years. and at the same time, he's vice president of the previously called Article 29 Working Party, which was the gathering, the collective wisdom, if you wish, of all European data protection authorities to align their thinking around legal questions of interpretation of the previous data protection directive, and now has transformed into the so-called European Data Protection Board, which has a bit more structure than the Article 29 Working Party and a bit more instructive powers than it had before under the General Data Protection Regulation. I'm very happy to have him here as well, because he will also give us the enforcement side with a lot of experience for 15 years now, more than 15 years of enforcement of data protection rules in Europe and especially in Belgium. So thank you for being here. And we'll start with Elizabeth. We'll proceed as follows: that we have two talks of roughly 20 minutes. But before we do so, we have to now see the impact question for this session. And I'll hope I can have a push maybe from the technical team, because I come without my iPad, to see the question that we'd like you to vote on. This is the question that we've chosen for this session, to see the impact of the talks. And I'll give you some time to connect. To what extent do you think that the current and coming legislation supports the MyData principles? And that's something I'm personally curious about, because we're not opening the discussion on GDPR today, because it just began to apply, obviously, but we will have to refine it over time. Maybe complemented at some point, not now, but at some point with additional legislation, and certainly also the judicial practice around the principles will refine the rights of the regulation. So I think we'll have a stable audience feedback for the moment. So we take a snapshot of that, and we'll see the results after the session later. Okay, with this, we can jump back to the presentation slides, and we'll start with Elizabeth.
Hi, good morning, everyone. My name is Elizabeth Renieris. I'm Global Policy Counsel at Evernym. It's a real pleasure to be at this conference. I'm really supporting the work that MyData is doing. It's a wonderful event, and it's an honor to be here with this distinguished audience. So the question I've been asked to address today is the new regulation old already? As many of you can guess by now, the new regulation, of course, referring to the General Data Protection Regulation, or the GDPR, which came into full force in effect in May of this year. But before I dive into it, just a bit about me. I already got a long introduction, so I've practiced and lived and worked in 5 countries on 3 continents. I have a very cross-border global perspective on things. I spent 8 years focused on data protection and privacy laws in the US and the UK and elsewhere, and I, in the last 3 years, have been very much focused on blockchain distributed ledger technologies and tokenization as well. And obviously now the two are very much converging conveniently, so I come from sort of that perspective. And perhaps a lesser known but more interesting fact about me is that I went to university with this guy.
Would you be comfortable sharing with us the name of the hotel you stayed in last night?
No. Of course, that's none other than Mark Zuckerberg of Facebook, and of course they've been in the news very much recently for all the wrong reasons. But perhaps there's a silver lining in all this, which is that our data is once again a cover story. So if you've been an American following the news in the last few months, you would certainly think that the regulation is, quote, new. Just have a look at some of the headlines recently. But in my presentation this morning, I want to take the position that this is in fact fake news, and that the regulation is in fact not so new from at least 3 perspectives: a historical, a technological, and a structural perspective. So a bit of history first. So the story of the GDPR actually starts approximately 70 years ago with an American woman addressing an international audience in Europe. Obviously not me, this woman. If she plays.
We stand today at the threshold of a great event, both in the life of the United Nations and in the life of mankind. this Universal Declaration of Human Rights may well become the international Magna Carta of all men everywhere.
So that, of course, is Eleanor Roosevelt, wife of the late President Franklin Delano Roosevelt. She was the chairperson of the committee that drafted the Universal Declaration of Human Rights, which was the first sort of international implementation of fundamental rights of the individual, including the right to privacy. I say privacy, and it's important to distinguish between privacy and data protection because they're, in fact, not the same thing. The origins of data protection are, in fact, in privacy law. You can see how privacy was largely construed as a freedom of interference within a physical, private sphere of the individual in respect of, effectively, his people, places, and things. So his persons, houses, papers, and effects, his privacy, family, home, and correspondence, and then imported into European law by the Council of Europe in the European Convention on Human Rights as respect for private and family life, home, and correspondence. And interestingly, in European law, having to do with interference by a public authority specifically, so a freedom from the state intrusion by public authorities. The notion of data protection wouldn't emerge for several decades later as a distinct legal concept, until, of course, the computer age, which we define as beginning roughly around the time that the US Department of Defense would introduce ARPANET and the first network that deployed TCP/IP. You can see the several decades in the interim where the law remains largely the same. And then, of course, we get the adoption of commercial and household computers. So in 1981, fewer than 1% of the US population had a computer. By 1995, at the time of the directive, more than a third of the US population owned computers. Similarly, in the UK, we went from less than 10% of households with computers in the 1980s to more than 30% in 1995. And so it's no coincidence that it's around this time that we begin to get sort of early data protection laws. Now, of course, computers challenged our traditional notions of privacy, and they challenged this idea of a physical sphere around the individual and this freedom of interference of his persons, places, and things. And so the concept of privacy didn't work as neatly as we hoped it would, which was the emergence of data protection. So it's no coincidence that many of the early national data protection type laws emerged in the countries where computers were most quickly adopted. Of course, these laws were very limited in scope and, again, often had to do simply with the public sphere, so protection from government databases and record keeping, and actually had very little to do with the border control function of privacy, but more to do with a gatekeeping function around who had access to our data and what they were authorized to do with that data. So if you think of privacy as sort of a physical moat, and data protection more as a gate that controls the rules around those who have been already given access to our data. So why did the directive emerge in 1995? We can see how some of the early data protection laws in countries emerged in the 70s and early 80s. So what took so long for a response in European law? Well, of course, the answer is geopolitical. So in the 90s, you had the movement towards a single market, the early proposals for a movement towards a single currency in the form of the euro, the Treaty of Maastricht in 1992 cementing the political union. And it quickly became clear that these divergences and differences in protection for individuals in the different member states was an obstacle to economic activity and had the potential to distort competition, which of course was a very compelling reason to revisit the law. And it wouldn't be another roughly 20 years until the next significant overhaul in the law in the form of the GDPR. So by the time we get to the GDPR, you can see the history and the legal evolution in the GDPR itself, which references approximately 20 distinct laws and regulations that came before it. So you can see how from a historical point of view, the new regulation is in fact not so new. Moving to a technological point of view. So technology growth from the time of the directive in 1995 to the first draft of the GDPR, which was leaked in 2011, officially published in 2012, was astronomical. So we get the transition from the read-only web to the read and write web, or Web 2.0. We get Google as a search engine in 1998, the introduction of platforms and social media giants such as Facebook, YouTube, and Twitter. Very importantly, the introduction of smartphones, so the first Apple iPhone in 2007 and the Android shortly thereafter in 2008. And of course, new communications technologies such as voice over IP technologies and Apple FaceTime. And let's not forget cloud computing, right? And from 2010 to 2012, we get the emergence of many cloud services providers, which further complicate the data landscape. So these changes are significant. But it took another 20 years to revisit the law. So the question, of course, is, what took so long? Well, the answer is roughly the same as the motivation for the directive. And if you look at the recitals to the GDPR, in fact, it's almost word for word the same reasoning provided for the directive, which was obstacles to the pursuit of economic activities and the distortion of competition resulting from uneven data protection laws in varying member states. And even this wasn't compelling enough, because for some of us, as we know, the draft GDPR actually sat around for several years without much attention and wasn't really prioritized until the digital single market strategy was announced in 2015. And the compelling reason there for the change, of course, was that harmonizing the law could add an additional 415 billion euro to the European economy. So some pretty compelling stuff there. But it took approximately 6 years for the GDPR to go from its first draft to the law as we know it today in full force and effect. And in those 6 years, the changes we've had have not only been astronomical in terms of their quantity and their rate of growth, but they've been qualitatively different changes. So they fundamentally changed how we live our lives. We're now living smart lives, right? In smart homes with smart technology and smartphones. We've got household augmented and virtual reality devices. We have voice-controlled home devices. We have the rise of the sharing economy, self-driving cars, and of course, more recently, the proliferation of blockchain and cryptocurrencies. So the sum total of all this is that the world as it is today, at the time of the GDPR, is unrecognizable from what it would have been when the first draft was introduced. Which means the law is clearly lagging behind technological innovation. Now, this is presenting a whole set of structural problems, which takes me to my third perspective, which is the structural one. And I want to propose that the GDPR is actually built on a number of stale assumptions that are creating significant challenges to implementation of the law. The first challenge is the consent framework. So the GDPR, like the directive before it, still has a framework of notice and consent, whereby the individual is provided with notice about the information being collected and processed, and a lawful basis for processing that data is consent of the data subject. Now, this was also a lawful basis under the directive, but whereas the directive allowed for opt-out consent, the GDPR requires specific, informed, and unambiguous affirmative action by the data subject. So what's the problem? Well, at the time of the directive, less than 1% of the world's population was online. And we can see how even in the time from the first draft to the GDPR taking effect, that population has ballooned to more than 4 billion people, nearly half the world's population. And not only are there more of us online, but we're doing more than ever before. So in 1 minute alone, we send approximately 156 million emails, 16 million text messages. We watch more than 4 million YouTube videos, swipe 1 million times on Tinder, and yes, tweet approximately 500,000 times. Google processes approximately 3.5 billion searches every day. So there are more of us online, and we're doing more online, which means the volume of data being created is growing at an astonishing pace. The digital universe is doubling in size every year. So just process that. So, excuse me, I don't think I can go back. There we go. So what does this mean for consent? Well, it means that we live in a world, and we're increasingly moving into a future where it is not going to be feasible or practical to send a push notification notifying the data subject and having them specifically consent to every single instance that requires the use of their data. It's just not tenable from a quantitative point of view. Moreover, from a qualitative point of view, we have extra challenges. So with the introduction of things like proprietary algorithms, AI and machine learning, neural networks, things that technologists themselves don't understand, how can we possibly expect the data subject to give informed and specific consent to every instance of their data? Clearly, consent is broken and is no longer a tenable framework for moving into the future as a lawful basis for processing. And I really think the law ought to acknowledge the reality. Which takes me to our next problem.
How do you sustain a business model in which users don't pay for your service?
Senator, we run ads.
Senator, we run ads. Okay, so we all know by now that the digital economy is built on advertising. Of course, it pays quite handsomely as advertising revenues have grown year on year in proportion to the volume of data being created. But the senator's question was in fact misguided, because we all know that we do pay for the service. And we pay in our data. And these volumes of data, as the advertising community is the first to admit, are basically the oil that greases the digital economy. And as the Interactive Advertising Bureau says, they're able to target end users in ways not previously possible. They can target an end user wherever they happen to be. Of course, that end user is us, which means we're target practice for advertisers. And by now, we all know that the pernicious effects extend well beyond unabated consumerism to interference with our politics and even our perception of reality. So we know these are harmful effects, but what makes it worse is that we're literally held hostage for and asked to pay ransom in our data. So I don't know how many have seen the IB Europe's cookie wall, but of course, what we know based on consent now is that this is basically an invalidly obtained consent mechanism because it's obviously not freely given. Moreover, how many people understand how cookies actually work? Which takes me to my third structural problem. So this is a map of our submarine telecommunications and fiber optic cables. You can see that our technology not only virtually connects us, but it in fact quite literally connects us. The law, of course, is still largely jurisdictional. So we have a tension between global technologies, data that doesn't respect borders, and jurisdictionally bound laws. So the GDPR has attempted to solve this issue by attempting to apply itself extraterritorially. So in Article 3, you can see how there are three bases for the GDPR to apply. The first is what is known as the establishment test, so it applies to a controller or processor established in the Union. The second is the activities test, which means that it applies to a controller or processor not established in the Union, but on the basis of certain activities, namely the offering of goods or services, or the monitoring of the behavior of data subjects who are in the EU. And lastly, on the basis of public international law. So this is what we refer to as the extraterritorial reach of the GDPR. Now, while theoretically a good solution for this cross-border challenge, it may have paradoxically created borders where they didn't exist before. So I don't know how many folks saw one of these in or around May 25th, but many of us woke up to a bifurcated web, right? So one for the Europeans and one for the rest of the world. Now, in a conventional service, we can put up these walls, albeit we can argue whether it's a good idea. But what about new and emerging technologies? What about truly global and decentralized technologies, which by their nature can't confine their borders? Well, we saw a number of those projects just close their doors entirely and shut down for business out of fear of being unable to comply and reconcile their business model and their nature with the new regulation. So you can see the deep structural problems from a jurisdictional perspective as well. Now, will these sort of commercial impediments to economic activity compel us to act just as it has before in the law? Do we need an international treaty on our data? So these challenges also present opportunities to sort of hack the law, right? To come up with new and innovative solutions. So I just want to propose a few. I'll say at the outset that none of this is easy, but it's certainly worth exploring. So we've seen how the notice and consent framework is no longer a tenable proposition. Again, we have too much data, and we qualitatively have a problem of trying to obtain informed consent of the data subject, which means that we now have to ex ante design and build products and services that promote and protect the rights of the individual. We can't, after the fact, expect to audit consent, right? So this is the genius of Article 25 of the GDPR, which is data protection by design and default. And the hope here as well is that, of course, technologies that do this will be more inherently commercially competitive, and for those of us that are familiar with the California effect in the US, hopefully raise the bar, just as California has done with environmental regulation in America. So data portability, a hidden gem of the GDPR, seemingly nothing to do with data protection or privacy. But if we go back to the revenue model that we saw, this has the real potential to realign incentives, to break up some of that monopolistic power of the intermediaries, to temper vendor control and prevent vendor lock-in, and to enable us to truly have some autonomy in respect of our data. So how many of you have downloaded your Google or your Facebook data? Or how many of you were afraid to leave Facebook for fear that you'd lose your photos, right, or your contacts? With portability, that's really no longer an obstacle to leaving. And so the consumer now has a lot more choice in walking away from a specific service provider or vendor. Finally, this is a really interesting letter from 1973 from the US Secretary of Health, Education, and Welfare on the Fair Information Practices, as they were known at the time, or FIPS. So he says that the problem is really that the relationship between the giver and receiver of personal data has grown more attenuated, impersonal, and diffused. And there was a time where this was done face-to-face, when it involved personal trust and a certain symmetry or balance between the giver and the receiver. And what's so interesting, of course, is you can imagine this being written today. The problem persists, that we have this attenuated relationship. And in fact, perhaps one of the best solutions is trying to restore some of that symmetry between the giver and receiver of the information, which of course is what we're trying to do with self-sovereign identity, is restoring some of that power to the individual. So, of course, we can try and unlock some of the hidden gems in the regulation. We can apply political and economic pressure and sanctions. And we can look to new emerging technologies that can help restore some of that symmetry, such as blockchain distributed ledgers, and also move towards a fully peer-to-peer ecosystem where you truly do have a symmetrical relationship and restore the balance of power. And of course, as I said, these are just some of the ideas. We don't have time to get into many more. But a very interesting prospect is also that over time, law and technology might even converge in a way where the law actually becomes an extensible technology that can map to changes and innovation, which may solve many of our problems in one fell swoop. So that is my presentation. Thank you.
Fantastic. Thank you very much, Elizabeth. Please keep using screen.io. I see the questions been pushed to the iPad here on stage. And I'll take one of the questions, because it's a very factual question that is put to you. And it reads, how about the Cloud Act? Could you briefly tell us about influences to EU and data protection privacy?
Yeah, so
Just speak.
Hi. Oh, okay. So I'm not an expert in the Cloud Act, but I think it's this was my point with the flag slide, as I call it, with all the different laws and regulations that are referenced in the GDPR alone. And I think it's important to take that sort of holistic perspective of we can't assess any of these laws or regulations on their own. They're all part of a contextual framework. They're all part of a strategy. And if you look at it in a similar way, in this tension between the rights of the individual and making sure that we promote sort of a healthy economy and protect any kind of distortion of competition, there's a similar tension going on there from a political perspective. So I think perhaps Willem could actually speak to this better, but that would be my advice, is to put things into context at all times.
Cool. Thank you a lot. So we will take questions in the final round, but first we'll have Willem. Very happy to have him here. We have slides from him as well. Here was a mistake from my side to push all the questions to the screen, which I didn't mean to do. But here are coming his slides and his presentation, enforcement of GDPR. And that's actually maybe the first subject I can announce and have your views for the panel, and take some of the comments also, that we will also look at the question of state enforcement versus consumer empowerment as one of the themes of this session. But first, we hold the talk.
Thank you, Malte. Good morning, everybody. I hope that we can, in the next 20 minutes, give you some explanations on how you can use the General Data Protection Regulation. And maybe that will be my starting point. The General Data Protection Regulation is a monster. is a monster that you can read with several mindsets. You can do it as an economist, you can do it as a lawyer, you can do it from administration, but you can also look to it how to empower the use of data by yourself, by the citizen, by what they call in the General Data Protection Regulation with an awful word, a data subject, but that is already a difficult word to pronounce. I will talk about the citizen. My idea is that you can use the General Data Protection Regulation also as a citizen, as an individual, as an NGO, as an activist, and that you can do that not only by acting yourself, going to the courts and so on, going to the Data Protection Authority, but also to say, to ask, to demonstrate to the data protection authorities, not only your national but also the European one, that they should use their competences, that they should make use of all the tasks that they have, and that you can enforce that as an individual. It's, I think, a very interesting and very challenging idea. You must know that data protection authorities are administrative bodies. I'm one of them. I know myself, I know my colleagues. We have a lot of work. We don't have all the resources. If you, as an activist, as a consumer protectioner, as an NGO, if you are forcing these data protection authorities, these commissioners, to act, to use their competences, well, they will be enforced, they will be obliged to do that. And I think that is very important. How you can do, we shall see it a little bit more. So that's the monster, the General Data Protection Regulations, 99 articles, a lot of recitals, a whole booklet. And what is important, when you are talking about the rights of the subject, you always look to the principles, of course, but also to the rights of the data subject. And when you see these rights, well, you have transparency, modalities, you have information, you have rectification, erasure, the last of this is Article 23, a very awful article, restrictions, because all the set of these rights can be by national law, by also European legislations can be contained, can be justified. So it's a very difficult chapter, a lot of promising articles. Practically 99% was already in the former legislation, in the directive. There was nothing real new in it, but of course you can use that. But you don't have to stop there. You have also to use the next chapter on the controller and the processor. I will give one example of what you can really use in your acting, and that is in the Article 25. It was already mentioned by Elizabeth, data protection by design and by default. And here I choose by default. It's new. And I think it's one of the testing articles of the failure or the real protectioning of the General Data Protection Regulation. If you read the text, you will say, what is that? But if you're thinking about the concept, privacy by default, it's very easy. You have the right to get in offering services, and you get by ICT, by technology, you have the right on a very good level of default protection of your data protection. That's so simple as that. It's a little bit more difficult when you read the legal text, but of course, legal texts are made by several people, and it is always the outcome of a lot of discussion, but you have to try to find out with legal text how you can protect the best your interest, the interest of the citizen. And that will be, I think, a very good proof for or the success or the failure of the General Data Protection Regulation. The proof of the pudding is in the eating. Well, the proof of the General Data Protection Regulation will be in the application of this new concept, for example, the concept of data protection by design and certainly by default. And we know already that a lot of companies are very struggling with this new concept. What will be the level of data protection that you are giving by default? Because everybody knows that what you are giving, what you are offering as a company, as an administration by default, that for 90% of the people, they will accept it, they will not change that. So that's an example of a new concept, what it can be very, very interesting in the application, but we shall see in next years if it is really usable. But you don't have to stop with chapter 4. You have also to look to the tasks and the competences of the data protection authorities. Data protection authorities are, as I already said, administrations. You have to use these administrations. You don't have to think, and I know that in the general data protection regulations and in discussions, everybody was thinking, okay, we have to empower data protection authorities and give them all the possibilities to act for the subject, for the citizen. But in my opinion, it is not enough. You have to use, as a citizen, the possibilities that are offered by the general data protection authorities, and also you have to use or misuse or to give more energy to the different tasks and powers of the data protection authorities. Let's look a little bit to all these tasks. You will see that it is really an enormous list of all sorts of specific tasks, and that some of them you can use. You can really say to the data protection authority, make use of, for example, the 57 R contractual clauses. That's international exchange of data protection. You have the right as a citizen to look out how it is working. And that can be, for example, these contractual clauses can be very important, because in these contractual clauses, there, in the international exchange of data, you will find on what level of protection, of default setting, the exchange will be there. And it's important because most of important companies are working on a global scale and have to make use of these contractual clauses or the binding corporate rules. Just a small example of what you can do with all these tasks. More important is Article 58, certainly powers, investigation powers, because it's always starting with an investigation, with a control, with an inspection. That's always a starting point for a data protection authority to see what has really happened, to see how they can enforce data protection. But of course, more important is corrections. Data Protection Authority had several possibilities to ask corrections, even in order to communicate personal data breaches, processing into operations into compliance, and much more, suspension of data flows. If you can suspend data flows, if you can give withdraw a certification, or for example, if you have also the power to stop a processing as a data protection authority, you see that there is really a very large, yet you can have a very large impact as a citizen, as an NGO, as a consumer. You cannot do that, but you can enforce the data protection authority to investigate what is at stake and what can be done. And even more, we come later to that. All these powers and tasks, it's very interesting to see how you can activate that as a citizen. And last but not least, you have this chapter on remedies, liability, and penalties. Well, the penalties, there was a lot of stuff about that, and the 4 to 2% or 4% annual turnover worldwide. Of course, that's a weapon of mass destruction. I don't think that the Data Protection Authority will make use of that immediately, but there is a lot of things that can be done. Article 84, suspension of proceedings, what already I've mentioned. And I think that's very interesting to look to that. You have Article 80, and as you will work as a community like MyData, it's very worthwhile to read Article 81 and Article 82. And for a lot of NGOs and for associations, it is already been used, for example, and we'll come to that by the actions of Max Schrems against Facebook. So I think it's very useful to read carefully this Article 80 and also recital 142, because that is a very interesting recital to your authority, your national authority. And even more interesting is the 143, when you have to handle decisions have been taken by the last resorts of the data protection authorities, the European Data Protection Board. New in the General Data Protection Regulation is that they now can take decisions who are binding for national states, for national authorities. That's completely new, because the Working Party 29 before could only give opinions, advices, directions, but not taking formally binding decisions. That is now the case. You can do that. And even more, if you're reading our recital 142, that's not the end. You can, as a citizen, as a natural or legal person, you had the right to bring an action for annulment of decision of the board before the Court of Justice, Luxembourg. I don't ask to do that immediately, but it is not possible because the European Data Protection Board has not already taken binding decisions, but in the coming weeks, we have a meeting at the end of September, and in the coming months, there will be certainly the case in some cases that we have to handle in the next months. So it is important to look to that. It is not the end. The end of all the discussions is always judicial review and is now in the hand of the European Court of Justice. It was not possible for the directive, but under the directive we had already the possibility as data protection authorities to take actions. And one of the examples that I will give is the action that has been taken by the Belgian Data Protection Authority against Facebook. When Facebook changed his terms and conditions unilaterally, it's always the case like that, and you have a few weeks to say, I'm okay, I'm not okay. If not okay, you are expelled of the service. At December of 2014, we had a meeting with the Working Party 29, and we, with the Germans, with the Dutch, with the French, the Spanish, and the Belgian authority, we said we are not agree with this way of working, and we asked, but appealed also Facebook not to do that, but there was a difficulty because other data protection authorities were not so severe. They were much more friendly for Facebook. But we started an action. We started by doing a very deep research, also by academics and universities, with the Germans, with the Dutch and the French and so on. And we have made a report in a few months, a report that was listing 10 points of special interest where we show an infringement of the existing European data protection legislation. One of them is very interesting. There was a sixth, was already the whole system that have been discovered in the Cambridge Analytica case. We choose, every country, every data protection authority have made a choice and say, okay, this issue, I will bring that in my legal enforcement. For the Belgium, it was very easy. We had to go to the court. We go to the court in 2015, September, we get a judgment, but it was an urgency judgment, who was saying that Facebook had to adopt his policy in order to not follow anymore people who were not member of the Facebook, what they call community. who had not an URL on Facebook, because we discovered that Facebook is not only following her members on their use of the internet, but also the people who are using internet without being member of Facebook. So the judge had recent warrant against that. There was an appeal. The Court of Appeal said we are not competent and there was no urgency. After that, in 2017, we discovered that there were new technology and new uses of this by Facebook. And then we came to new recommendations, and a year later, on the 16th of February of this year, we became a new ruling of the Court of Justice of Brussels, who was saying that the use of from Facebook from personal data was illegal, completely illegal. Of course, appeal, and we now are waiting to have this case before the Court of Appeal of Brussels in March 2019. So we have to wait a few months. But what we are doing with the Data Protection Authority has not been the work only of the Data Protection Authority. It was the work of a lot of people, of the university, of a research group on social networks from several Belgian universities who work together to give the information that you need to do such an investigation. General Data Protection Regulation, the question was raised already. Elizabeth talked about new technologies. It's also at stake in not only the European Union, but also in the Council of Europe, where you have a very interesting report that just has been published, the report that has been asked by the Council of Europe, and who is advocating on 2 potential new human rights. Legal stuff is not stopping with the General Data Protection Regulation. You have to adopt such things. And you need, of course, not only new legislation, you need legislation who is at most so technological neutral as possible. And therefore you will see that there will be, that there is a proposal for new data protection human rights. One of them is right to not be measured, analyzed, and coached. Another one is, it's very simple, but it's a little bit strange to read, that right to meaningful human contact. That should be a human right, a new human right in data protection. But if you are interpelled by that, read this report, very interesting. Very interesting is also the work of academics, like, for example, Bruce Schneier. We had, in the case against Facebook as Data Protection Authority, we could use a lot of insights that were provided by the work of Bruce Schneier. And also the actions that have been done before by not a Data Protection Authority, but by an individual, by an activist, Max Schrems, who had been, so to say, the founding father of the actions against Facebook, and also his actions were inspiring for the German, for the Dutch, for the French, for the Spanish, and the Belgian Data Protection Authority to start this action against Facebook. So that's my final point. I will only give you one additional information. A year before, in September 2017, the Belgian Data Protection Authority had proposed a statement to the International Convention of Data Protection Authorities, and it has been accepted. And this statement was that we should work together with consumer organizations, with NGOs, with the trade unions, with organizations like MyData, and not still only work in the field of the Data Protection Authority. And this statement has been accepted by the conference. We will have, at the end of October in Brussels the next international conference, who is now organized by the European Data Protection Supervisor, Giovanni Buttarelli, and one of the points that we have to discuss is how to make this statement now reality. Thank you for your interest. Thank you.
Thank you very much, Willem, for this really, really great talk with a lot of pointers. And I can see from the questions that pop in, really great questions coming through the tool, that we have a lot of interest. I'll first take maybe some that I'll, one that I'll take myself. Is the EU acting on making the law a bit more explainable? Indeed, there's two comments. One saying, I have even a GDPR reading club that tries to spread the gospel. But what we did from the Commission side, it was understood that it's very, very hard for individuals or for companies, even smaller companies, to understand what the rights mean. So there's, I think, a relatively good set of explanatory slide decks. I recommend you to find them yourselves. But the colleagues in DG Justice have done just that. But indeed, for laws, there is lawyers, and it's their business to basically advise you in individual cases. So if you have that's the problem, that you always will need a lawyer if you really want to know what happens in your instant case. But two questions for Willem, which are about examples first on what companies did data protection by design in an exemplary way. Do we already have such examples? And secondly, whether you have examples that the intervention power to stop data flows has been actually enforced by any of the DPAs you know. Maybe not yet, because data protection by design is only a recent right. So do we already know about the company? I mean, have you seen anything?
Well, we know that a lot of companies are struggling with the question, and that they are trying to set up. And the whole question is, what is an acceptable level of data protection that you have to offer by default? So that's something that you have to look out case by case. You cannot use a general formula for that. If you are reading Article 24, the first of this chapter on the duties and what have to be done by controllers, by processors, you see very clearly that in this article that they are always looking to the context, to the risk analysis, risk-based approaches, and very important new concept in the General Data Protection Regulation. To give one example of the stopping of processing, we in Belgium, we were confronted, we have new legislations, elections, and in the weeks, months before the election, you can use a lot of tools that are offering by newspapers. Where am I here as an individual? What should I choose? You have 20, 30, 40 questions on specific items. And then they said, yeah, the outcome is that you should vote for Social Democrats or for the Greens or for the Nationalists. And we discovered that it was not only neutral, but also that the data, the personal data of people were processed by the whole system of processing and was analyzed afterwards, even in a point that it could be that it was not anonymized. So we stopped directly on the spot in 1 hour the processing. We sent letters by email to these newspapers. It were newspapers and one academic institution. They accepted because it was not so clear. They could say we don't do that and we have to enforce, or we go to the court. They could go to the court. They have accepted. We had a meeting a few hours already the same day after that. We explained our concerns. Okay, they said, okay, we did not know, and but of course it was bullshit. But they accepted, and maybe they knew already before that it was dangerous what we are trying to do. But of course, you are always having problems. The academic said, yes, but it is not anonymized, but we are in a very secure situation. We will not misuse this data, but it's not a question of misusing. It is you use this data, you cannot do that. So that's one example, a very fast and easy example, because they accepted the whole questioning. We have had before discussions with Google, the Google Street View. Also there, after a lot of discussion, they have adopted their system because it was clearly a breach of the data protection legislation. They have also accepted a fine that was given, not by us, because we didn't have on that time the possibility, but a fine that was given by the prosecutor. The whole question with Facebook is much more something completely different. They are extremely hostile. The discussions are very, very hard. Let's say that there are no discussions. The only discussion is see you in court. But we hope still that there will be a change. They have said in the introduction of the case before the Court of Appeal in Brussels a few months ago, just a week or 4 weeks before the start of the General Data Protection Regulation on the 25th of May. And there they declared there will be no problem anymore because Facebook has adopted the whole system, taking into account data protection by default, by design, and there will be no problem in the next and coming days. I see in the press few days ago that it's not the case, that there are still a lot of discussions running. We shall see in March what will be the outcome. But we have already some experience, but I think that to have a first overview of the possibilities, the failures or the success of the General Data Protection Regulation, we should take, I think, 1 year to make this full assessment.
Great. I'll push another set of questions to the screen, which goes around now digital identities and blockchain and how the GDPR, let me just find them because there's so many great questions. So there's two. Does the GDPR allow identifiers such as digital IDs on a blockchain? And how will the GDPR deal with blockchains that store public keys of individuals for very strong security reasons but are immutable? Maybe something more for you. The two questions.
Hello? Okay. Yeah, sure. I mean, so I've been an active participant in the EU Commission's Blockchain Observatory. We've very much been dealing with these questions. One thing I will say is that we don't have definitive answers yet. On the question of decentralized identifiers or DIDs, one thing to understand about personal data is near everything at this stage is really personal data because the definition is so broad, right? It's anything that relates to an identified or identifiable individual, and we know that it includes pseudonymous data as well. So the level of anonymization that has to be achieved to come outside the scope of personal data is really an incredibly high bar to meet. So there's generally an assumption that something is personal data if it relates to a natural person. Now, of course, that wouldn't be the case with an entity or a thing in the case of IoT. So while we don't have express guidance on DIDs per se, we do have guidance from the Article 29 Working Party that will be imported into the European Data Protection Supervisors guidance as well around public keys and public addresses being personal data. So we can see how, of course, a decentralized identifier, right? It's an identifier. So even in its on its face would be something that is identifiable to a natural person. So I think it's a reasonably safe assumption, and those of us in the working group have been taking the view that this most likely is personal data. Now, of course, that doesn't mean that you can't use it, right? We couldn't exist in a world where you can't use personal data. It just means that you have to adhere to the principles and find a way to give effect to data subject rights, which is obviously where the questions around erasure come in. There's been a lot of concern, and as I mentioned in my presentation, a number of blockchain projects have basically shut down out of a fear that they couldn't comply and give effect to the right to erasure. Now, erasure is a very complex subject. Again, we don't have specific guidance in respect of blockchains and what this would mean, but we know that there's some precedent for the idea of effective erasure. There's some precedent for something that's been sufficiently erased from a technical point of view where it's no longer within the scope of personal data, and so there's some opportunity in there. However, there is definitely the perspective that the notion of immutability, to the extent that's true, and of course that depends on the type of ledger and the type of blockchain, and it's not universally applicable, but to the extent that something is immutable, there's definitely a high risk of storing any kind of personal data there, and so of course the best practice is to never put that personal data on the chain in the first place, or on the ledger in the first place. But I think, as we've both mentioned, I think it's going to take some time to get some actual guidance on this, and it's something that is on the forefront of at least the Commission's mind, because these technologies are moving very quickly, and there's certainly no desire that I've seen to really kill a whole new area of innovation, and I think there is a desire to try and reconcile the law. One other thing I'll mention about erasure, of course, is that, like many of the rights, it's not absolute, right? So there are certain situations, conditions that need to be met in order for erasure to apply. And it's conceivable that there are some contexts where erasure wouldn't apply in some of these settings. So it's definitely important to take a very nuanced view of the purpose of putting that data there and how you might actually comply with erasure to the extent that it's actually applicable.
Yeah, maybe also a question before you reply, Willem, to you. How do you select topics for guidance? I mean, what's the process, the inner workings of the previous working party and on the board to actually pick and choose subjects that you think interesting, and how are these opinions been developed and discussed?
Well, I think there are two main ways how we make this selection. The first of all is, of course, questions. We had about 5,000, 6,000 questions in the last years from citizens, from NGOs. We have a lot of questionings by the legislators. So that is, of course, the first way to take, okay, we have to pay attention to that. Secondly, that is the new technologies. In the first stage, we don't have so much questions from citizens or from the legislator, but you see that there is a lot of questioning on new technologies. Blockchain is one of them, for example. And if you combine that with the principles of the General Data Protection Regulation, for example, right to be forgotten is one of the great obstacles with blockchain. If you see that in practice, right to be forgotten is for 95% related to press, to mass media, then you see directly that if you want to use blockchain for press and mass media, you are entering a very difficult area, because you know that the right to be forgotten is incompatible, and you have a lot of discussions on the right to be forgotten in press, in browsers, of course. It is always with browsers related also. So it's clear that if you are using this risk analysis approach, that you say blockchains and mass media, newspapers and so on, no way. That is, for the moment, you cannot use that, because there is not knowledge enough how you can handle that. Is that the same, for example, with health data? Oh, there also a very difficult area, health, and it's also extremely now in progress. There are a lot of new technologies, the exchange of information. It's not anymore the relation one-to-one, you as a patient to your doctor, practitioner. No, you are now as a patient in front of a whole group of persons, institutions, researchers, economics, and so on. So it's a new area. And how to handle that, I don't think that you can use blockchain for that, because on this moment we are really not capable to do that. So we are, that's the 2 points. Questions from governments, from legislators, for the citizens, a lot of them are saying how to handle that. And on the other hand, new technologies and how we can make an approach on that. That's the 2 main factors. But of course, as for example, if I read the manifesto of MyData, well, also organizations like MyData can also influence that in putting forward questions, in putting forward studies, because the stronger you are in having a strong dossier, if you can give a good, elaborated and well documented question, you are of course much more stronger to ask really that there should be a position of data protection.